I landed in Nashville at 6:15 a.m. after 8 months in Dubai. The project was done, delivered on time, under budget by $4 million. I'd earned the drive home. I came around the final bend and stopped completely. My guest wing was gone. Not damaged, not vandalized. Gone. And the main house, my 9,400 square foot lake mansion, restored at a cost of $3.8 million, was 30% demolished. A notice stapled to what remained of my front door read, "Delinquent. Dues unpaid 8 months. Authorized demolition. Karen Hollis, HOA President." My dues were current. Autopay for 6 years. Karen's system couldn't match a corporate name to a property account. Instead of making a phone call, she sent in the bulldozers. What Karen never bothered to check is that I don't just own a home in Lakeview Heights. I own all 847 acres it's built on. Every road, every common area, the lake, the ground beneath all 340 homes, the ground beneath her home. I bought the master deed in 2019 for $28 million. Every homeowner in Lakeview Heights owns their structure and leases the land beneath it from me. Karen demolished the home of her own ground lessor. She lost her house. Her HOA was dissolved. The judge awarded me $7.2 million. I rebuilt my east wing 800 square feet larger than before. When you own the land, you can afford to be patient. Before we dive into the story, comment where you're watching from and make sure you're subscribed for more stories like this. I landed at Nashville International at 6:15 a.m. on March 3, 2025. 8 months in Dubai. 8 months of 14-hour days, contractor negotiations, permit battles with foreign municipal authorities, and the particular exhaustion that comes from managing a $340 million mixed-use development across a 12-hour time difference from home. The project was done, delivered on time, under budget by $4 million. I'd earned the flight home. I cleared customs, collected my bags, and drove my rental car south toward Lakeview Heights. The familiar Tennessee countryside rolled past in the gray early morning light. I'd made this drive dozens of times over 6 years. Every time I came back from a project, this drive felt like decompression, the gradual slowing of a mind that had been running at full capacity for months. By the time I turned onto Lakeview Drive and headed north toward the lake, I was already thinking about breakfast on my deck. Coffee, the water, quiet. I came around the final bend in the road and stopped, completely stopped. Foot on brake, engine running, staring. My guest wing was gone. Not damaged, not vandalized. Gone. The 2,400 square foot structure that had occupied the eastern side of my property, 4 bedrooms, 3 bathrooms, a full kitchen, a covered porch overlooking the lake, had been reduced to a concrete foundation and a pile of rubble. Broken drywall, splintered timber, shattered glass ground into the earth. And the main house, my 9,400 square foot lake mansion, the original developer's residence, built in 1962 and restored by me over 2 years at a cost of $3.8 million, was 30% demolished. The entire east wing of the main structure had been torn open. I could see the interior rooms exposed to the open air. My study, the guest bedroom, the hallway with the original oak paneling I'd spent 4 months sourcing period-accurate restoration materials for. Ripped open, partially collapsed, construction fencing surrounding the entire property. I sat in my car for 60 seconds. Then I got out. The morning air smelled like concrete dust and cut timber. Even 2 weeks after whatever had happened here, the smell of demolition hung over the property. I walked through the construction fencing. There was no lock, just a latch, and stood in what had been my guest wing. The foundation was exposed, still solid, the concrete my grandfather's generation had poured to last a century. But everything above it was gone. In the rubble pile at the eastern edge of the property, I could see fragments of the custom tile I'd imported from Portugal for the guest wing bathrooms. Pieces of the hand-built cabinetry I'd commissioned from a woodworker in Asheville. I pulled out my phone and started photographing. Systematic, methodical, the way I documented construction sites for 30 years. Wide shots first, then medium, then close-ups of specific damage, the foundation, the rubble pile, the exposed interior of the main house. the construction fencing with its orange warning notices, and stapled to what remained of my front door, a yellow notice, official-looking, weathered by 2 weeks of March rain. Lakeview Heights Community Association Notice of Demolition Order. Property, 1 Lakeview North Drive. Status, delinquent. Dues unpaid 8 months. Action, authorized demolition pursuant to LHCA bylaws. Section 12, Article 4. Abandoned and Blighted Property Ordinance authorized by Karen Hollis, HOA, President. Date of action, February 14th to 18th, 2025. I read it 3 times. Then I called Richard Cole. Richard had been my property attorney for 14 years. He'd handled the Lakeview Heights acquisition in 2019, structured the Blackwood Capital Holdings purchase, and reviewed every ground lease in the development. If anyone understood exactly what had just happened here, and exactly what it meant, it was Richard. He answered on the second ring. "Tori, you're back. How was—" "Richard, they demolished my house." Silence. "Say that again." "Lakeview Heights, HOA. They issued a demolition order while I was in Dubai. The guest wing is completely gone. The main structure is 30% demolished. There's a notice on my door signed by the HOA president." A longer silence. "Tori, are you at the property right now?" "Standing in the rubble of my guest wing." "Don't touch anything else. Don't move anything. Don't speak to anyone from the HOA until I get there. I'm leaving in 20 minutes. "Richard, I know what this means. I'll be there in 2 hours. He hung up. I stood in the rubble and thought about how I came to own this place. I'd been in real estate development for 30 years. Started at 28 with a single duplex in Nashville, purchased with $40,000 in savings and a bank loan I'd spent 6 months qualifying for. Built that into a portfolio, then a development company, then Blackwood Capital Holdings, which by 2019 had completed projects in 12 states with a combined value exceeding $800 million. I'd seen hundreds of properties in 30 years, evaluated thousands. Most of them were straightforward: buy land, build structures, sell, or hold. Lakeview Heights was different. It was a relic, a 1962 luxury development built around a private lake in southern Tennessee by a developer named Harold Whitfield, who'd had the unusual foresight, or unusual greed depending on how you looked at it, to retain ownership of all the land while selling only the structures. Ground lease community. Homeowners in Lakeview Heights owned their houses, their walls, their roofs, their fixtures, their foundations. But the ground those foundations sat on? Harold Whitfield's. And when Harold's estate sold off assets in 2019, the master deed, all 847 acres of Lakeview Heights land, came to market. I bought it through Blackwood Capital Holdings for $28 million. Every road in Lakeview Heights, mine. Every common area, mine. The lake itself and its shoreline, mine. The land beneath all 340 homes, mine. The land beneath the HOA clubhouse, mine. The ground lease agreements were all properly recorded, all legally binding, all renewed automatically under the original 1962 terms, unless formally renegotiated. For 6 years, I'd been the quiet ground lesser, collecting lease income, maintaining common areas, living in the original developer's mansion, the crown jewel of the development, and working on projects overseas. I'd never had a conflict with the HOA, until now. I walked to my car, got my laptop, and pulled up the HOA dues payment records. Blackwood Capital Holdings LLC paid HOA dues on the mansion quarterly, automatic transfer from the company account. Every payment on time for 6 years. The most recent payment, $2,847.50, transferred August 12, 2024. The HOA had received it. The bank record showed the transfer cleared. But someone at the HOA had apparently not recognized Blackwood Capital Holdings LLC as the owner of 1 Lakeview North Drive. Someone had decided the property was delinquent, and that someone had pushed through a demolition order without doing the basic due diligence of verifying who actually owned the property and whether dues were actually unpaid. Richard arrived at 10:30 a.m. He walked the property with me in silence. He was 61, methodical, the kind of attorney who communicated through precise language and long silences rather than dramatic speeches. He'd seen a lot in 35 years of property law, but when he stood in the rubble of my guest wing and looked at the exposed interior of the main house, even he went quiet for longer than usual. "This is extraordinary," he finally said. "How bad is it legally, for them?" "Tory, they demolished a private structure on private land without the owner's consent, without proper legal process, and without verifying basic ownership facts. This isn't an HOA overreach case. This is tortious destruction of private property, potentially criminal depending on how the contractor was engaged." "What's the exposure?" "Guest wing replacement value, $1.4 million construction cost, plus contents and improvements. Main structure partial demolition, $1.8 million minimum, plus diminution of value to the remaining structure, plus your time, plus punitive damages given the willful nature of the act." He paused. "I'd put it at $6 million to start, with punitive exposure potentially doubling that. They have $380,000 in reserves. I know. And their liability insurance won't cover this. Demolition of private property on land the HOA doesn't own. That's not a community standards enforcement action. That's property destruction. No policy covers that." I nodded. "Then they're going to need to find money somewhere else." Richard looked at me. "You're thinking about the ground leases. Karen Hollis demolished my home. She did it on land I own. That's a material breach of the ground lease structure. Every board member who voted for that demolition order is potentially in breach. You have the right to terminate for material breach. It's in the original 1962 agreements, carried forward through the 2019 assignment." "I know." We drove to the HOA clubhouse at noon. It was a handsome building, original 1960s timber construction, well-maintained, with a covered entrance and a view of the lake I'd spent $180,000 landscaping 2 years ago. Built on land I owned. Karen Hollis was in the main office. She was in her early 50s, well-dressed, with the particular confidence of someone who'd held a position of community authority long enough to confuse it with actual power. She stood when I walked in. "Mrs. Blackwood, I was wondering when you'd be back." "Miss Blackwood, or Tory, I'm not married." I sat down across from her desk without being invited to. "You demolished my house. We issued a demolition order on a delinquent property that had been abandoned for 8 months. We followed proper procedure under HOA bylaws section. I pay HOA dues through Blackwood Capital Holdings, LLC. Your notices went to the wrong address. The payments have been current for 6 years. Karen frowned. "We have no record of dues payments from an entity by that name. Check your bank records. August 12, 2024. $2,847.50. Blackwood Capital Holdings, LLC. She pulled up something on her computer. A flicker of something crossed her face. Not quite recognition, not quite alarm. Not yet. "That payment is recorded as unidentified commercial payment. It wasn't matched to a property account. Because your accounts receivable system didn't recognize the corporate name. Instead of making a phone call to verify, someone declared the property delinquent and issued a demolition order. We sent notices to the wrong address, the property management company that handles my residential correspondence. They forward mail monthly. I was in Dubai." I looked at her steadily. "You demolished a $4.2 million structure on land that I own, and I own considerably more than just that parcel." Karen's frown deepened. "What does that mean, more than that parcel?" "Have your attorney pull the master deed for Lakeview Heights, the complete master deed, recorded with the county in 2019 under Blackwood Capital Holdings, LLC. I stood. "Then call me." I set my business card on her desk. Her eyes went to the card, then back to me. I walked out. That evening, I sat in the intact portion of my mansion, the western wing, still standing, untouched, and looked out at the lake through windows my father's generation had installed, with wavy glass that distorted the water slightly, the way old glass does. I'd bought this house because it was beautiful, because it was the original developer's vision for what Lakeview Heights could be, because after 30 years of building things for other people, I wanted something I'd built for myself. Karen Hollis had demolished a third of it, because she hadn't verified who owned the property, because she hadn't traced a corporate dues payment, because she'd looked at a large house sitting quiet for 8 months and seen blight instead of ownership. She was going to call me tomorrow after her attorney explained the ground lease situation, and that conversation was going to go very differently than this one had. Because Karen Hollis thought she'd demolished an abandoned mansion, she'd actually demolished the home of the woman who owns the ground her house is built on. I'd been patient for 6 years. That patience had just run out. Karen called at 9:17 a.m. the next morning. I was sitting on the intact portion of my deck with coffee, watching morning light move across the lake. The demolished east wing was visible from where I sat. Exposed framing, scattered rubble, the concrete foundation of the guest wing standing clean and empty. I let it ring twice before answering. Ms. Blackwood. Karen's voice was different from yesterday. The authority was still there, but something underneath it had shifted, a tightness. I've asked our HOA attorney to review the master deed situation you mentioned. Good. He'd like to meet with you this morning, along with myself and the board. I'm available at 11. We'll see you then. She hung up before I could. I arrived at the clubhouse at 10:58 a.m. Richard was with me. The HOA board was assembled in the main conference room. 8 people seated around a rectangular table, Karen at the head. 6 board members I recognized from community communications, and at the far end, a man in his late 40s I didn't know. Gray suit, wire-rimmed glasses, a yellow legal pad in front of him covered in handwritten notes. Mrs. Blackwood, Karen said, this is our HOA attorney, Philip Garrett. Philip Garrett stood and extended his hand. His handshake was firm, but his eyes were careful. The eyes of a man who'd spent the last 18 hours reading documents that had fundamentally changed his understanding of the situation he was managing. Ms. Blackwood, thank you for coming. We sat. Philip Garrett opened a folder. Inside was a copy of the master deed, the complete 2019 transfer of Lakeview Heights land from the Whitfield estate to Blackwood Capital Holdings, LLC. 87 pages of property description, ground lease assignments, and recorded easements. I've reviewed the master deed and the associated ground lease agreements, Philip said carefully. I want to confirm my understanding before we discuss next steps. Go ahead, Richard said. Blackwood Capital Holdings, LLC, purchased the Lakeview Heights master deed in October 2019. The purchase included all land within the 847-acre development boundary, including all road corridors, common areas, lake frontage, and the individual parcels upon which all 340 residential structures are built. Correct, Richard said. Philip looked at Karen. Each homeowner in Lakeview Heights owns their residential structure. The land beneath that structure is owned by Blackwood Capital Holdings and occupied by the homeowner under a ground lease agreement originally executed in 1962 and automatically renewed under those original terms. Karen's jaw was tight. Meaning what, exactly? Meaning the homeowners don't own the land their houses sit on. They own the buildings. The land is Ms. Blackwood's. The room went very quiet. A board member on Karen's left, a man named David Chen, who I knew from community newsletters as the HOA treasurer, looked at Philip with an expression that mixed comprehension with something approaching dread. All the land? Including beneath our houses? Including beneath every residential structure in Lakeview Heights. Including beneath this clubhouse. Another silence. Longer this time. Karen shook her head slowly. That can't be right. These people own their homes. They have mortgages. They have deeds. They have deeds to their structures, Philip said carefully. Their mortgages are secured against the structure value and the leasehold interest, not against the land. The land has always been under separate ownership since the development was built in 1962. Harold Whitfield retained land ownership when he sold the original structures. That was the original development model. Ms. Blackwood's company purchased that land ownership from Whitfield's estate in 2019. The ground lease structure has been continuously in effect for 63 years. Karen turned to me. You never disclosed this. It's public record, I said. Recorded with the county in October 2019. The ground lease terms were disclosed to every homeowner at original purchase and at every subsequent resale through the title process. Every mortgage company that's ever underwritten a loan in this development received copies of the ground lease as part of their title package. Nobody told us you'd bought the land. Nobody asked. Karen's expression cycled through something complicated. Disbelief, calculation, the beginning of something that looked like fear but wasn't ready to admit itself yet. This doesn't change what you owe in HOA dues, she said, pivoting. Richard smiled slightly. Ms. Hollis, my client's HOA dues are current. We've already established that. The payment was received and deposited. Your accounts receivable system failed to match it to a property account. That's an administrative failure on the HOA's part, not a delinquency on my client's part. The notices were sent to the wrong address. The property is listed under a corporate entity. Standard due diligence requires verifying ownership before initiating a demolition order. A 10-minute search of the county property records would have shown that the property is owned by Blackwood Capital Holdings. A phone call to the number listed in those records would have reached my client's property management team within 24 hours. Philip Garrett put his pen down. Mr. Cole is correct, Karen. The delinquency determination was procedurally flawed. Karen looked at her attorney with the expression of someone who'd expected him to be on their side, and was discovering the limits of that expectation. Philip, I have to give you my honest assessment. The property was not legally delinquent because the dues had been paid. The notices were not properly served because they went to an address not associated with the corporate owner. The demolition order was issued without verification of ownership or proper legal standing, and the demolition was carried out on private property, specifically on land owned by Ms. Blackwood, without her knowledge or consent. The board member to Karen's right, a woman I recognized as Sandra Vickers, who'd sent a strongly worded letter to the community newsletter about abandoned properties 6 months ago, spoke up quietly. Philip, what is our exposure? Philip looked at his legal pad. The formal demand letter from Ms. Blackwood's attorney arrived this morning. I reviewed it before this meeting. He slid a copy toward the center of the table. Richard had sent it at 7 a.m. Formal demand for stamper for damage. Blackwood Capital Holdings letter. It's been $33.50 of the program and the description for 18 that he said. Formal demand for this meeting. / Victoria Blackwood versus Lakeview Heights Community Association. Property damage. Complete demolition of guest wing structure. 2,400 square feet. Replacement cost. $1,400,000. Contents and custom improvements, $800,000. Subtotal, $2,200,000. Property damage, partial demolition of main residence, 30% of 9,400 square feet structure. Structural repair and restoration, $1,800,000. Custom improvements and period-accurate materials, $600,000. Subtotal, $2,400,000. Diminution of property value, ongoing, $800,000. Additional damages, disruption, displacement, loss of use, $600,000. Total demand, $6 million. Payment due within 30 days. Failure to pay will result in immediate filing of civil suit and exercise of all available remedies under the ground lease agreements. Sandra Vickers read the letter twice. $6 million. Yes, Philip said. We have $380,000 in reserves. I know. Karen looked at the demand letter, then at me. She's trying to intimidate us. She's a corporation. She can't do this. Philip's voice was measured. Karen, she can absolutely do this. The grounds are solid. The damages are documented. And as the ground lessor, she has additional remedies beyond civil suit that standard property owners don't have. What additional remedies? Philip hesitated. Richard spoke. Under the original 1962 ground lease agreements, carried forward through the 2019 assignment, the ground lessor may terminate a ground lease in the event of material breach. Causing damage to ground lessor property constitutes material breach under Section 14, Paragraph 3 of the Standard Lease Agreement. The room absorbed that. David Chen, the treasurer, put his pen down carefully. Material breach, he said slowly. Ground lease termination. Yes, Richard said. If our leases are terminated, your mortgage lenders would be notified. A ground lease termination triggers an acceleration clause in most mortgages secured against leasehold interests. Your lenders would have the right to call your loans due. Sandra Vickers went pale. Our mortgages would be called? That's the potential consequence of ground lease termination for material breach. Yes. The silence that followed was complete. Karen broke it. She can't terminate 340 leases. That's the entire community. She doesn't need to terminate all of them, Richard said. She needs to terminate the leases of the board members who voted for the demolition order. Every head at the table turned, very slowly, toward Karen. Karen's expression had changed completely. The authority was gone. What remained underneath was something raw. "Philip," she said quietly, "can she do this?" Philip Garrett looked at his yellow legal pad for a moment. Then he looked up. "Yes, under the terms of the ground lease, the material breach provision is clear and has been upheld in Tennessee courts in prior ground lease cases. If the board voted to authorize the demolition of ground lessor property, that action could constitute material breach by the board members who authorized it." The board member at the far end of the table, a man named Robert Marsh, who joined the board 8 months ago, cleared his throat. "For the record," he said, "I did not vote for the demolition order. I voted against it, twice. I also submitted a written objection and tendered my resignation from the board on January 15th, when it became clear the majority was going to proceed." He slid a document across the table, a copy of his resignation letter, dated January 15th, 2025, 1 month before the demolition. Another board member, a woman named Patricia Walsh, reached into her folder and produced an identical document, her own resignation letter, dated January 17th. "I also objected and resigned," she said. "I told Karen that we had not properly verified ownership and that the demolition order was premature. I was told I was being obstructionist." Karen looked at both of them. "You're protecting yourselves." "We're telling the truth," Robert said. "We told you to stop. You overruled us. You pushed this through with 6 votes. Now Ms. Blackwood is in this room, and she owns the land under all of our houses. And you're telling her she can't do anything? She's bluffing." "Karen," Philip Garrett's voice was firm, "she is not bluffing. I have reviewed the ground lease documents. I have reviewed the 2019 assignment. I have reviewed the material breach provisions. Every legal tool her attorney described is real, available, and supportable." Karen looked at me. I'd been watching the entire exchange from across the table without speaking. "What do you want?" Karen asked. "What I want," I said quietly, "is my house back, which you can't give me because you demolished it. We can negotiate. My attorney will communicate with yours about next steps." I stood. "But Karen, I want you to understand something clearly. I have been a patient ground lessor for 6 years. I've maintained these common areas. I've kept the lake clean. I've invested in this community because I believed in it. And while I was overseas building a project that employed 340 people, you demolished my home because your accounts receivable system couldn't match a corporate name to a property account." I picked up my copy of the demand letter. $6 million is what it costs to rebuild what you destroyed. The ground lease remedies are what happen if you fight it. I walked out. Richard fell into step beside me in the parking lot. "The 2 board members who resigned. That's significant. It shows the demolition wasn't unanimous. Reduces the HOA's ability to claim good faith." "I know. Karen's going to fight this." "I know that too." I looked back at the clubhouse, a beautiful building, well-maintained, sitting on land I owned. "Richard, pull the individual ground lease files for Karen Hollis and the 6 board members who voted for the demolition. I want to review the material breach provisions tonight." "Tonight?" "Tonight." He nodded. We got in our separate cars. On the drive back to my partially demolished mansion, I passed 340 homes, every one of them sitting on ground I owned, every one of them occupied by people who'd bought their structures in good faith, raised their families, built their lives. Most of them had nothing to do with Karen's decision. I had no interest in punishing them. But Karen Hollis had voted to demolish my home, and she was about to discover exactly what the ground beneath her feet was worth. The notices went out on March 10th, 2025. Richard had spent 4 days preparing them. Each one was individually tailored to the specific board member's ground lease agreement, the original 1962 document, the subsequent renewal terms, and the 2019 assignment to Blackwood Capital Holdings. Each one cited the specific vote record, showing the board member's affirmative vote on the demolition order. Each one cited Section 14, Paragraph 3 of the ground lease agreement, the material breach provision. 7 days after my return from Dubai, 7 days after standing in the rubble of my guest wing, 7 days after sitting across from Karen Hollis in the clubhouse conference room, the certified mail envelopes left Richard's office. 6 went to the board members who had voted for the demolition order. 1 went to Karen Hollis. She got hers first. Richard had arranged it that way deliberately. Karen's envelope was sent by priority overnight. The others went standard certified mail. I wanted her to know what was coming before it arrived at everyone else's door. The notice read, Notice of Ground Lease Review, Potential Material Breach 2. Karen Marie Hollis, Re. Ground Lease Agreement, Lot 47, Lakeview Heights Development. Lessor, Blackwood Capital Holdings, LLC. Lessee, Karen Marie Hollis. This notice advises you that your ground lease agreement dated June 14, 1962, as renewed and assigned, is under formal review for potential material breach pursuant to Section 14, Paragraph 3 of said agreement. The basis for this review is as follows. On or about February 14th to 18th, 2025, the Lakeview Heights Community Association, acting under your authority and direction as HOA President, authorized and carried out the demolition of structures located at 1 Lakeview North Drive, property owned in fee simple by Blackwood Capital Holdings LLC, your ground lessor. This action constitutes damage to ground lessor property. Under Section 14, Paragraph 3, any action by a lessee or any organization controlled by or acting under the direction of a lessee that causes material damage to ground lessor property constitutes material breach of the ground lease. You are advised that Blackwood Capital Holdings LLC is evaluating all available remedies under the ground lease, including, but not limited to, formal notice of termination. Ground lease termination would extinguish your leasehold interest in Lot 47. You are advised to consult with an attorney immediately. This notice does not constitute formal notice of termination. It is a notice of review. You have 21 days to respond through counsel. Richard Cole, Attorney at Law. On behalf of Blackwood Capital Holdings LLC/Victoria Blackwood, Karen received it at 9:45 a.m. on March 10th. I know the exact time because she called me at 9:52 a.m. You cannot be serious. Good morning, Karen. You're threatening to terminate my ground lease? I've lived in this house for 11 years. I'm notifying you that your lease is under review for material breach. Those are different things. You're trying to take my home. I own the land your home is built on. Your home is still yours. But your right to occupy the land it sits on is governed by the lease agreement you signed, which you apparently never read. I read my purchase documents. Did you read the ground lease, specifically Section 14? Silence. Karen, Section 14, Paragraph 3. Material breach includes any action by the lessee or organization under lessee direction that causes damage to ground lessor property. You authorize the demolition of my home. My home is on my property. That's the definition of damaging ground lessor property. We thought it was abandoned. We thought it was blighted. We were enforcing community standards. You thought wrong. You didn't verify. You didn't call. You didn't do a 10-minute county records search. You issued a demolition order and you executed it. And now you're looking at the consequences. This is extortion. You're using the lease as a weapon to force a settlement. No, extortion would be threatening to do something I have no legal right to do in order to extract money. I have an absolute legal right to terminate a ground lease for material breach. I'm notifying you that I'm evaluating that right. That's not extortion, that's contract law. You'll destroy this community. Your demolition order destroyed my home. I'm protecting my property rights. Karen's voice dropped to something cold and flat. I will fight this with everything I have. Then fight it. My attorney's information is on the notice. Have yours contact him. I hung up. The other 6 notices arrived the following morning. I didn't hear from those board members directly, but Richard did. By noon on March 11th, he'd received 6 calls from 6 different attorneys, all of them asking the same questions in different words. Is this real? Can she actually do this? What are the grounds? How do we respond? Richard's answers were consistent. Yes, it's real. Yes, she can do it. The grounds are clearly stated in the notice. Respond in writing within 21 days. By the afternoon of March 11th, something else was happening. The notices were supposed to be confidential, between Tori, Richard, and the individual recipients. But in a community of 340 homes where everyone knew everyone, confidentiality lasted approximately 4 hours. A board member had told his wife. His wife had called her neighbor. Her neighbor had texted the community Facebook group. By 3 p.m., Lakeview Heights was in full panic. I watched it develop from my partially demolished mansion. My phone rang 11 times between 3 and 6 p.m. Numbers I didn't recognize. Residents calling the ground lessor directly because they'd gotten my number from the county property records. I didn't answer. I let them go to voicemail. The messages were a spectrum of human emotion. Confusion. Ms. Blackwood, I'm not sure I understand what's happening. Is it true you own the land under my house? My realtor never mentioned this. Fear. Please call me back. I have a mortgage. I need to understand if my loan is at risk. I had nothing to do with the demolition. Anger. This is outrageous. We are homeowners. You cannot threaten people's homes over an HOA dispute. And, from a few people, something that surprised me. Acknowledgement. Ms. Blackwood, I'm so sorry about your home. I thought something was wrong when I saw the demolition happening. I want you to know I had no part in this decision, and I support your right to defend your property. The Lakeview Heights Community Facebook group was a running document of the community's collective processing of the situation. David, my neighbor, one of the ones who'd watched the demolition and said nothing, posted, "Can someone explain the ground lease situation? I bought my house 10 years ago, and my realtor said I owned it." Philip Garrett, the HOA attorney, posted a careful statement. The ground lease structure is a feature of Lakeview Heights that predates the current ownership. Homeowners own their structures. The land is owned by Blackwood Capital Holdings. This has been the case since 1962 and was disclosed at all real estate transactions. Homeowners should review their purchase documents. Karen posted nothing. At 7 p.m., an emergency community meeting was announced. The following evening, mandatory attendance requested. I wasn't invited, but I knew what would happen. Richard called at 7:30. The community meeting is going to be rough for Karen. She's the one who pushed the demolition. She's the one whose actions triggered the lease review. The residents are going to want answers she doesn't have. Good. Tori, I want to talk about the non-implicated residents. The 332 homeowners who had nothing to do with the demolition vote. Their leases are fine. Their homes are not at risk. But they don't know that yet. The panic spreading through that community right now is because people think all 340 leases are under review. Set the record straight. I'll send a community notice tomorrow morning. Something that clearly states that only the 6 voting board members plus Karen are under lease review. The other 333 households are unaffected. Do it. I have no interest in frightening people who did nothing wrong. It'll help de-escalate the broader community panic, but it'll concentrate the anger on Karen and the 6 board members. That's appropriate. They're the ones who authorized the demolition. The community meeting happened the following evening. I had it on good authority, from Robert Marsh, the board member who'd resigned in protest and who'd become something of an informal liaison, that it lasted 3 hours and 40 minutes. Karen stood at the front of the room and tried to explain her position. The property had appeared abandoned. The dues were delinquent according to HOA records. She'd followed the bylaws. The room didn't accept it. One woman stood up and asked, "Karen, did you know she owned all the land when you issued the demolition order?" "We didn't have that information at the time." "Did you look for it?" "We conducted standard due diligence." "Did you look for it?" Karen had no clean answer. A man in the third row. "My mortgage is secured against a leasehold interest. Do you understand what that means? If my lease is called into question, my lender can accelerate my loan. You put my financial stability at risk to demolish someone's house without checking who owned the land." Another resident. "I've lived here for 16 years. I paid $540,000 for my home. I just found out I don't own the ground it's on. And now the person who does own it is reviewing leases because our HOA president made a decision without doing basic research." The anger in the room wasn't abstract. These were people whose homes, whose mortgages, whose financial lives were suddenly connected to a decision Karen had made. Robert Marsh told me afterward that Karen had tried to reframe the issue. positioning herself as a victim of my corporate overreach, suggesting I was weaponizing the ground lease to extract money. The room hadn't bought it. A retired attorney in the back row had stood up and said, quietly, that material breach provisions in ground leases were standard, enforceable, and completely legitimate. That if the HOA had demolished property owned by the ground lessor had every right to invoke those provisions. That Karen's characterization of it as extortion was legally incorrect. Karen had looked at him across the room. "Whose side are you on?" "The side of anyone who reads their contracts," he'd said, and sat back down. By the end of the meeting, a petition had been circulated calling for Karen's immediate resignation as HOA president. It had 187 signatures before the meeting adjourned. I sat on my intact deck that night, the demolished east wing dark and silent to my right, the lake reflecting the stars below me. The 6 board members who'd voted for the demolition were consulting attorneys. Karen was facing a resignation petition. 340 households were grappling with the reality of ground lease ownership. Property values in Lakeview Heights had already dipped. Zillow estimates were down 8% on comparable homes, reflecting the uncertainty. None of this gave me my guest wing back. None of it restored the original oak paneling in my study's exposed hallway. But it meant that Karen Hollis was no longer the person with authority in this community, and that the ground beneath her feet, ground she'd lived on for 11 years without truly understanding who owned it, was now the subject of a legal review that her own attorney couldn't reassure her about. She'd demolished my home because she thought I was absent and powerless. Now she was the one watching her position crumble, one notice at a time. Karen filed suit on March 18, 2025, 8 days after receiving her ground lease review notice. The complaint was 23 pages and argued 3 things: that HOA bylaws supersede individual property rights and community standards matters, that 6 years of accepting HOA governance constituted implicit consent to demolition authority, and that the ground lease review notices should be immediately enjoined as tortious interference. Richard brought it to my makeshift office in the intact western wing that afternoon. I read it twice. "Implicitly consented to HOA governance authority," I said, "by paying dues." That's their argument. I paid dues because the ground lease requires it. That's a contractual obligation, not consent to demolition authority. I know. It's the only theory they have. HOA bylaws can govern aesthetic standards, maintenance requirements, architectural review. They cannot grant authority to demolish structures on land the HOA doesn't own. You can't write a bylaw that overrides property law. When's the injunction hearing? April 3rd, Judge Warren Holloway. I know Holloway. He reads the documents. Richard filed our counterclaim on March 21st. 3 causes of action. Tortious destruction of private property, $6 million. Punitive damages for willful and reckless conduct, $2 million. Ground lease enforcement confirming our right to proceed with material breach termination proceedings. Total, $8 million plus ground lease enforcement. The community received news of both lawsuits within 48 hours. The Facebook group ran hot for 3 days. The resignation petition for Karen reached 241 signatures, 71% of all households. Karen issued a statement. "The board is confident in our legal position and committed to defending the community's right to enforce its own standards. We will not be intimidated." Robert Marsh sent me a copy with a 1-line note. "She's losing the room." On April 3rd, we appeared before Judge Warren Holloway in Davidson County Circuit Court. Karen's lead attorney, Douglas Pierce, made the opening argument. "Your Honor, the Lakeview Heights Community Association has governed this development for 63 years. When Ms. Blackwood purchased the ground lease portfolio in 2019, she accepted the HOA bylaws as the governance framework. She cannot now invoke an obscure provision of a 1962 lease document to threaten 7 community members who were enforcing established standards." Judge Holloway looked up. "Counsel, can HOA bylaws grant demolition authority over structures on land the HOA doesn't own?" Pierce hesitated. "Your Honor, the bylaws establish comprehensive community standards authority. Yes or no? Can a bylaw grant demolition authority over a third party's property? Not in isolation, but in the context of the broader governance framework. The answer is no. Continue." Pierce argued the implicit consent theory, 6 years of accepting HOA governance without objection, acceptance of dues obligations, participation in the community framework. Judge Holloway looked at Richard. Mr. Cole? Richard stood. Your Honor, paying contractually required HOA dues is not a waiver of property rights. The HOA's authority extends to community standards within the development. It does not extend to demolishing the property of the ground lessor who owns the land the entire development sits on. Furthermore, the property was not abandoned. Dues were paid. The owner was overseas on business, and the HOA's failure to identify the corporate owner and serve proper notice does not transform temporary vacancy into abandonment. Judge Holloway picked up the ground lease document. Let me see Section 14. He read it for 3 minutes in silence. Then he looked at Pierce. Section 14, Paragraph 3. Material breach includes any action by the lessee or organization under lessee direction that causes material damage to ground lessor property. The HOA board members are lessees. They directed the HOA to demolish the ground lessor's property. How is that not textbook material breach? Your Honor, the board members acted in their capacity as HOA officials, not as individual lessees. The lease doesn't carve out an exception for official capacity. It says any action by the lessee or organization under lessee direction. That's clear language. The property appeared abandoned. Counsel, you've said that 3 times. Appearances don't override property law. If I appear to be standing on public land, but I'm on your private property, my perception doesn't give me demolition rights. He set the document down. The plaintiff's request to enjoin the ground lease review is denied. Blackwood Capital Holdings has a clear legal right to invoke the material breach provision. That right is not subject to injunction by the parties whose breach triggered the review. Karen, seated behind Pierce, closed her eyes briefly. The HOA's abandoned property ordinance cannot expand its jurisdiction beyond its legal boundaries. The HOA loses on that question. We'll proceed to the damages hearing. April 24th. I want full construction documentation, appraisals, contractor records, and every board meeting minute discussing the demolition, including dissenting votes and resignations. He looked at Pierce. Did anyone search county property records for ownership before authorizing demolition? Pierce checked his notes. Based on current information, no, Your Honor. Holloway wrote something on his pad. We were adjourned. Outside, Richard turned to me. He's going to rule for you on damages. The only question is how much. The damages hearing ran 2 full days, April 24th and 25th. We presented every receipt, every contractor invoice, every custom material order. 2 independent contractors testified on restoration costs. The HOA's expert tried to argue the guest wing was of minimal architectural significance. Judge Holloway asked him one question. Are you saying the guest wing wasn't worth $1.4 million to replace? I'm saying the market value, replacement cost. The owner wants to restore her home. What does that cost? Based on current construction rates and custom specifications, approximately $1.3 million. Thank you. On May 2nd, Judge Holloway issued his 61-page ruling. The HOA had no legal authority to demolish structures on property owned by Blackwood Capital Holdings, LLC. Bylaws cannot grant jurisdiction over property the HOA does not own. The abandoned property ordinance cannot supersede property law. The HOA failed to conduct basic due diligence. A county property record search would have identified the owner within minutes. Compensatory damages. Guest wing demolition, $2,200,000. Main residence partial demolition, $2,400,000. Diminution of value, $800,000. Loss of use, $600,000. Total, $6 million. Karen Hollis personally drove the demolition despite written objections from 2 resigning board members. This conduct was willful and reckless. Ms. Hollis is personally liable for punitive damages, $1,200,000. HOA reserves of $380,000 are subject to immediate seizure. Remaining balance of $5,620,000 plus Ms. Hollis's personal judgment of $1,200,000 remain outstanding. I read the ruling at my kitchen table. Morning light fell across the pages in long rectangles through the western wing windows. The HOA had $380,000. They owed $6 million. And Karen Hollis, who'd called me an extortionist for invoking a lease provision she'd apparently never read, was personally liable for $1.2 million. Richard called at 10 a.m. The $380,000 seizure happens this week. Ready to discuss next steps? I looked out at the demolished east wing. Concrete foundation. Open sky where my guest room ceiling used to be. Let's talk about Karen's lease. The HOA's $380,000 reserves were seized on May 9, 2025. A court officer appeared at the Lakeview Heights clubhouse at 9 a.m. with the seizure order. The HOA's operating accounts were frozen. The reserve funds transferred to the court's registry as partial satisfaction of the $6 million judgment. It left the HOA with nothing. No operating funds, no reserves, no ability to pay staff, maintain common areas, or service any of the community obligations that 340 households depended on. The remaining judgment balance, $5,620,000, hung over the organization like a structural failure, visible, irreversible, impossible to ignore. Philip Garrett, the HOA's attorney, filed a motion requesting a payment plan. Judge Holloway denied it. The defendant had $380,000 in reserves at the time of the judgment. Those reserves are now applied. The remaining balance is immediately due. If the defendant cannot satisfy the judgment, the plaintiff has full rights to pursue all available collection remedies. All available collection remedies. Richard and I both knew what that meant in this context. The ground leases. Karen filed for personal bankruptcy on May 14, 2025. Chapter 7. Full liquidation. She listed $1.2 million in liabilities, her punitive damages judgment, against personal assets that included her Lakeview Heights home, a retirement account, and a savings balance. Her bankruptcy attorney's strategy was straightforward. Discharge the judgment debt, protect the retirement account under federal exemptions, and restructure around the home. But there was a problem with that strategy. Her home's value was inseparable from the ground lease. Without the ground lease, without the right to occupy the land beneath her structure, her $680,000 home was worth considerably less. The structure alone, without land rights, appraised at $190,000, and her ground lease was still under formal review for material breach. I had waited to make the termination decision formal until the court's punitive damages ruling was in writing. Now it was. Judge Holloway had documented Karen's willful and reckless conduct in 61 pages of judicial findings. Richard sent the formal ground lease termination notice on May 16th, 2 days after her bankruptcy filing. The timing was not accidental. Notice of Ground Lease Termination 2. Karen Marie Hollis. Ground Lease Agreement. Lot 47, Lakeview Heights Development. Pursuant to Section 14, Paragraph 3 of your Ground Lease Agreement, Blackwood Capital Holdings LLC hereby provides formal notice of termination of your ground lease, effective 30 days from the date of this notice. The basis for termination is material breach, as documented in the findings of Davidson County Circuit Court, Judge Warren Holloway, May 2, 2025. The court found that your conduct in authorizing the demolition of ground lessor property was willful and reckless, causing $1,200,000 in documented damages to Blackwood Capital Holdings LLC. Upon termination of your ground lease, your leasehold interest in Lot 47 will be extinguished. You are advised to notify your mortgage lender immediately, as termination of the ground lease may trigger acceleration provisions in your mortgage agreement. Richard Cole, Attorney at Law, on behalf of Blackwood Capital Holdings, LLC. Karen's mortgage lender received a courtesy copy the same day. The lender, a Nashville bank that had underwritten her home purchase 11 years ago, reviewed the notice and did exactly what the acceleration clause required. They issued a formal demand letter to Karen within 72 hours. The outstanding mortgage balance on her home was $412,000. With the ground lease terminated, their collateral had dropped from $680,000 to $190,000, a structure sitting on land the borrower no longer had legal rights to occupy. The bank called the loan due. Karen had 30 days to pay $412,000 she didn't have. Her bankruptcy attorney tried to argue that the ground lease termination was retaliatory and should be stayed by the bankruptcy court. The bankruptcy judge reviewed the ground lease documents, the material breach provision, and Judge Holloway's findings. He denied the stay. The termination is contractually grounded in a documented material breach that predates the bankruptcy filing and was established by independent judicial finding. It is not a creditor action subject to automatic stay. The termination stands. Karen listed her home for sale on June 1, 2025. The listing price was $195,000. Structure value only, explicitly noted in the listing as leasehold interest extinguished, land not included. Buyer assumes title to structure only with no ground lease rights. No serious buyers came. Who buys a house with no land rights? The home sat on the market for 6 weeks. Then Karen accepted an offer from a demolition contractor for $87,000, essentially salvage value for the structure materials and fixtures. She moved out on July 15, 2025. 11 years in Lakeview Heights, ended by a demolition order she'd pushed through without checking who owned the land. I heard through Robert Marsh that she'd moved to an apartment in Franklin, Tennessee, that she'd surrendered her HOA board position in late May, that the remaining board members had declined to issue any statement on her behalf. She left quietly. No farewell post on the community Facebook group. No letter to residents. Just a moving truck and a closed door. The 6 remaining board members who'd voted for the demolition were navigating their own situations. All 6 had received ground lease review notices in March. All 6 had hired attorneys. All 6 had spent April and May watching the lawsuit develop with increasing anxiety. After Judge Holloway's ruling, I had Richard reach out to each of their attorneys with a settlement proposal. The terms were straightforward. Each board member would provide a signed statement acknowledging that the demolition was unauthorized and that they had voted for it without adequate due diligence. Cooperate fully with any subsequent insurance or contractor investigations, and pay a reduced personal contribution toward the outstanding judgment, $85,000 each, totaling $510,000 across the 6. In exchange, I would withdraw the ground lease termination review for their individual properties, not pursue additional personal liability claims, and consider their leases fully reinstated upon payment. 5 of the 6 accepted within 2 weeks. They were homeowners who'd made a bad vote in a board meeting. They weren't malicious. They'd trusted Karen's judgment and her assurances that the demolition was legally sound. They'd been wrong, and they knew it now, and they wanted their ground leases safe. $425,000 collected across 5 settlements. Ground leases reinstated. Cases closed for those 5. The 6th, a man named Gerald Foster, who'd been Karen's most vocal ally on the board, rejected the settlement and hired aggressive litigation counsel. His attorney filed a motion arguing that his board vote was protected by HOA business judgment rules and couldn't constitute individual material breach. Richard filed a response in 12 pages. Gerald Foster settled 3 weeks later for $110,000, more than the original offer, plus a public acknowledgement of the breach. Total personal contributions from the 6 board members, $535,000. Combined with the $380,000 reserve seizure and the $87,000 from Karen's home sale proceeds applied through the bankruptcy proceedings. $1,002,000 toward the $6 million judgment. Still, $4,998,000 short. But the gap was closing through a mechanism Karen had never anticipated. The HOA itself, unable to pay, unable to operate, unable to maintain community obligations, had begun the formal dissolution process in late May. The dissolution required a community vote. It passed with 79% approval. The homeowners were exhausted. They wanted the legal exposure ended, the ground lease uncertainty resolved, and a fresh start. Media coverage had found the story by mid-May. A Nashville business reporter ran a piece titled, "Developer Demolishes HOA's Authority After HOA Demolishes Her Mansion." It ran in the Nashville Business Journal and was picked up by 3 national real estate publications. The piece was thorough. It laid out the ground lease structure, the demolition, the judgment, the lease terminations, Karen's bankruptcy, and the HOA's dissolution. It included a photograph of my partially demolished East Wing. The comment sections were merciless toward Karen. She didn't check who owned the land before demolishing a mansion? I would have checked on day 1. Basic due diligence. The ground lease structure is the most fascinating part. She literally demolished the home of the person who owns the land her house is on. One comment, from someone who identified as a real estate attorney in Texas, simply read, "This is what happens when HOA board presidents confuse community authority with property rights. They are not the same thing. They are never the same thing." The remaining residents, the 333 households who'd had nothing to do with the demolition, formed a community negotiating committee in late May. 7 residents, led by Robert Marsh, approached me directly with a formal request. They wanted to negotiate a new ground lease framework, one that was transparent, clearly documented, and communicated to all homeowners as part of standard disclosure. They wanted new HOA governing documents that explicitly acknowledged the ground lease structure. They wanted a relationship with their ground lessor built on clarity, instead of the 6-year ambiguity that had allowed Karen's misconceptions to fester unchecked. I met with them on June 3rd. They came prepared, a 40-page proposal, fair terms, good faith written into every paragraph. I read it that evening. Robert called the next morning. "What do you think?" "I think you've done serious work, and I think the community deserves a ground lessor who communicates clearly." "Does that mean you'll negotiate?" "It means I'll negotiate honestly, which is all I ever wanted from anyone in this development." We scheduled formal negotiations for June 20th. Karen Hollis had demolished my home because she thought I was an absent corporate entity with no personal stake in the community. She'd been wrong on both counts. I'd built my career on understanding exactly what I owned and making sure everyone else understood it too. I'd been patient for 6 years. I'd asked for nothing unreasonable. I'd paid my dues, maintained the common areas, and left 340 households to live their lives on land I owned without interference. And when one of them crossed a line so fundamental that she'd taken a bulldozer to my front door, I'd enforced the contracts, precisely, completely, without apology. Karen was gone. The HOA was dissolved. The judgment was being satisfied piece by piece, and the community that remained, the 333 households who'd done nothing wrong, were sitting across a table from me in good faith, ready to build something honest. That was worth rebuilding for. 6 months after standing in the rubble of my guest wing, I stood in the same spot and watched a crane lift fresh timber framing into place. October 2025. The reconstruction had begun in July, 3 weeks after the Community Negotiating Committee, and I reached the first terms of the new ground lease framework. The timing wasn't coincidental. Once the community uncertainty resolved and the legal exposure clarified, I had the financial foundation to move forward. The $535,000 in board member settlements, the $380,000 in seized reserves, the proceeds from Karen's home, together with my own resources, funded the rebuild. I'd hired Ashworth Construction out of Nashville, the same firm that had done the original restoration work on the mansion when I'd purchased it in 2019. They knew the building. They knew the materials. They knew what the East Wing had looked like before Karen Hollis decided it was blight. The project manager, a quiet man named Dale Whitmore, had walked the site with me in late June before work began. "We can restore it to exactly what it was," he said. "Same footprint, same materials, period-accurate everything." "I don't want exactly what it was." He looked at me. "Bigger? Better." The guest wing was 2,400 square feet. Build it at 3,200. Same architectural language as the original. I want it to look like it always belonged here, but more of it. Dale smiled slowly. "That I can do." The foundation work began July 14th, framing in August. By October, the structure was taking shape, the bones of something larger and more confident than what had been demolished. I watched the crane work from the edge of the site, coffee in hand, and thought about the difference between building and defending. I'd spent 30 years building, hotels, mixed-use developments, residential communities across 12 states. I understood the satisfaction of watching a structure rise from cleared ground, the way a building begins as an idea and becomes, through discipline and resources and time, something permanent. Defending was different. It required a different kind of patience, not the forward momentum of construction, but the still, absolute certainty of someone who knows exactly where they stand and refuses to move. Karen had tried to move me. Instead, I'd moved her. The new ground lease negotiations had concluded on September 8, 2025. 47 days of formal sessions with Robert Marsh's community committee. Patient, detailed, occasionally tense, but always productive. The new framework replaced the 1962 boilerplate with a modern document that said clearly what had always been true and what far too many people had failed to understand: the key provisions. Every homeowner in Lakeview Heights occupies land owned by Blackwood Capital Holdings, LLC, under a ground lease agreement. This fact must be disclosed prominently in every real estate transaction involving properties in the development. Every purchase agreement, every listing document, every mortgage application must include a one-page ground lease summary, written in plain language. Ground lease terms: 99-year renewable leases at fixed annual rates, with increases capped at 3% per year. Transparent, predictable, fair. Ground lessor responsibilities: maintenance of all common areas, roads, and lake access, all things I'd been doing anyway, now documented, now accountable. Homeowner rights: clear description of what they owned, structures, what they leased, land, and what protections they had against arbitrary lease termination. The material breach provisions remained. They were legitimate and necessary, but the new document spelled out exactly what conduct could trigger them, so nobody could claim surprise. And a new provision I'd insisted on: an annual ground lease community meeting, where I or my representative would meet with the homeowner community to answer questions, address concerns, and maintain the transparency that 6 years of silence had failed to provide. Robert Marsh had pushed for that last one. If you'd held that meeting in 2020 and explained the ground lease structure clearly, half of what happened might have been avoided. He was right. I'd been a passive ground lessor, collecting income, maintaining infrastructure, staying out of community affairs. I'd assumed the legal disclosures at purchase were sufficient. I'd assumed people understood what they'd bought. Karen's misconceptions had festered in that silence. I wouldn't let that happen again. The new HOA was formed on October 1, 2025. Lakeview Heights Community Association. The name was kept, the corrupted board discarded entirely. Robert Marsh was elected president. Patricia Walsh, the board member who'd resigned in protest over the demolition, was elected vice president. David Chen, the treasurer who'd asked the right questions in the conference room, was elected treasurer. Their first act as a board was to formally adopt the new governing documents, the ones that explicitly acknowledged the ground lease structure, the ones that clearly defined HOA authority as extending to community standards within structures and common area governance, and nothing further. No abandoned property demolition ordinance, no authority to act against ground lessor property, no ambiguity about where their jurisdiction ended. Their second act was to send me a formal letter. Dear Ms. Blackwood, the new board of the Lakeview Heights Community Association wishes to acknowledge the harm caused to you by the actions of the previous board. We commit to a relationship of transparency, mutual respect, and clear understanding of the respective rights and responsibilities of homeowners and ground lessor. We look forward to building that relationship. I read it at my kitchen table and then filed it in the folder labeled Lakeview Heights, New Chapter. Property values had begun recovering in August. The uncertainty that had driven them down 25% in the spring, the ground lease panic, the legal exposure, the HOA dissolution, had resolved as the new framework took shape. By October, Zillow estimates on comparable homes were back to within 8% of pre-crisis levels. By December, several homes had sold at prices slightly above their pre-crisis comparables. The new ground lease disclosures, counterintuitively, were helping. Buyers who understood exactly what they were purchasing felt more confident than buyers who discovered the ground lease structure after the fact. Clarity, it turned out, was worth more than comfortable ambiguity. Realtors who listed Lakeview Heights properties were now leading with the ground lease structure rather than burying it in the fine print. One listing agent told me the honest framing was actually a selling point for certain buyers, people who wanted the community amenities and the lake access, but preferred a lower purchase price in exchange for the annual lease payment. The development was finding its identity. What it had always been, finally properly understood. Richard came for dinner in early November. The reconstruction was nearly complete. The new east wing stood proud and full. 3,200 square feet of period-accurate architecture that matched the original mansion's language while adding the square footage that Karen's demolition order had, in a strange way, given me the opportunity to expand. Dale Whitmore had done exceptional work. Standing at the east end of the property and looking at the full mansion, original western wing, new eastern wing, restored guest structure, it looked like it had always been this size. Like the original developer had intended exactly this proportion when he'd built the crown jewel of his development in 1962. We sat on the completed deck after dinner, Richard with bourbon, me with coffee, the lake spreading out below us in the November dark. The water was still, the lights of the other Lakeview Heights homes reflected in soft, broken columns on the surface. Richard looked at the new east wing. It's bigger than it was. Yes. Karen demolished 2,400 square feet, and you rebuilt 3,200. I had the opportunity to correct something I'd always thought was slightly underproportioned. He laughed quietly. Only you would find an upside in having your house demolished. We sat in comfortable silence for a moment. Was it worth it? Richard asked. All of it. The legal process, the months of living in half a house, the community panic, destroying Karen's HOA. I looked out at the lake. I didn't destroy Karen's HOA. Karen destroyed Karen's HOA. She made a decision without reading the contracts, without checking the county records, without listening to the 2 board members who told her to stop. She authorized a demolition crew to tear down the home of the woman who owns the land this entire development sits on. I paused. I enforced the contracts that have been in place since 1962. Nobody read them. That's not my problem. Karen would say you were heavy-handed, the ground lease terminations, the personal liability. Karen demolished my home. What exactly was the appropriate response? Richard swirled his bourbon. Some people would have just sued for damages and taken the settlement. Some people. I built a real estate career on understanding exactly what I owned and making sure everyone else understood it too. If I'd settled quietly for whatever the HOA's insurance offered, which was nothing because they didn't have coverage, I'd have been signaling that you can demolish a property owner's home and negotiate your way out of it. That's not a signal I'm willing to send. And Karen specifically? I thought about Karen standing in her clubhouse office in her carefully pressed blazer, telling me I was confused about my own property boundaries, handing me a brochure about community standards, calling the ground lease review extortion. Karen didn't lose her home because I wanted revenge, I said. She lost it because she demolished mine. The lease said what it said. She breached it. I enforced it. That's contract law, not vendetta. Richard nodded slowly. Below us, the lake was perfectly still. Somewhere on the far shore, a light moved slowly along the water's edge, a resident walking their dock. A completely ordinary November evening in Lakeview Heights. My development, my lake, my land. 333 households living their lives on ground I owned, now fully understanding that arrangement and at peace with it. A new board running a functional HOA with clear governing documents and no illusions about where their authority ended. A rebuilt mansion, larger than before, better documented than before, protected by contracts that were now properly understood by every party involved. Richard finished his bourbon and stood. I'll say this. In 35 years of property law, I've never seen a ground lessor exercise leverage quite like that. Most ground lessors don't have their homes demolished. Fair point. He picked up his jacket. Tori, for what it's worth, you were right from the first day. About all of it. I walked him to his car. On my way back to the deck, I stopped at the edge of the new east wing and put my hand against the fresh timber framing. Still slightly rough, not yet fully weathered into the old confidence of the original structure. It would get there. Everything I'd built had started rough and become permanent. This was no different. I went back to the deck and looked out at the lake for a long time. 63 years ago, Harold Whitfield had stood somewhere on this shore and decided to build something that would last. He'd retained the land because he understood that land was the foundation of everything, of value, of leverage, of permanence. He'd been right. I'd bought that foundation in 2019 for $28 million because I understood the same thing he had. The structures change. The homeowners come and go. The HOA boards rise and fall. But the land stays. And the land was mine. I hadn't built a real estate empire by letting people destroy my property and walk away. I'd built it by knowing exactly what I owned, and making sure everyone else knew it too.